5 seconds to go. Start. Learned Senior Counsel submitted that even otherwise the judgment rendered per incurium does not form ground for review. In this regard, Learned Counsel relied upon a bench decision of Jammu and Kashmir High Court in National Insurance Company versus Muhammad Sultan Asim and another 2005 AIHC 1616. Learned Senior Counsel submitted that the contentions raised in the review petitions were specifically incorporated in the SLP filed on behalf of the state, yet no relief was granted by the Supreme Court and the SLP has been rejected with the reasons, and therefore the same cannot be permitted to be raised all over again by way of review petition. The relief claimed by the petitioners on the specific grounds not granted by Supreme Court shall be deemed to have been rejected. In support of the contention, Learned Senior Counsel relied upon the decision of the Supreme Court in State Bank of India versus Ram Chandra Dubey and others 2001-1 SCC 73. Learned Counsel submitted that the earlier decision of a coordinate bench upholding the virus of Rule 5 of the Rules of 2010 was specifically referred on behalf of the state before the Supreme Court, and thus it cannot be said that the order rejecting the SLP has been passed by the Supreme Court in ignorance of the said decision. According to the Learned Counsel, when both the bench decisions of the court in respect of the virus of Rule 5 of the Rules of 2010 were there before the Supreme Court, and after reconsideration, if the SLP has been rejected, obviously the decision under review has been approved. In this regard, the attention of the court was drawn by the Learned Counsel to para 9 of the decision of the Supreme Court in Bablu Singh's case Supra, relying upon a bench decision of the Bombay High Court in the matter of Srimati Emilia Tinoco, deceased by LRS versus Shashikant Nogesh Gad and others, AIR 1997, Bombay 319. Learned Counsel submitted that when both the views of this court were before the Supreme Court and one has been accepted by the Supreme Court, the plea of per inquirium cannot be entertained. Learned Counsel submitted that as a matter of fact, after dismissal of the SLP by the Supreme Court with reasons, the review petition filed is gross abuse of the process of the court. Learned Senior Counsel submitted that the review sought on fresh grounds is beyond the power of review under Order 20 Rule 1 CPC, and thus the petitioners cannot claim rehearing of the matter on fresh grounds. Reliance is placed in this regard on decisions of the Supreme Court in Collector of 24 Parganas and others versus Lalit Mohan Malik and others, AIR 1988 SC 2121, Lily Thomas versus Union of India and others, AIR 2000 SC 1650, and Nihali Panjiara and others versus Shyama Devi and others 2002 10 SCC 578. Learned Counsel submitted that the High Court has no power to grant the relief beyond the pleadings, and thus the grounds which are sought to be raised by way of review petition, which were not raised in pleadings before the writ court, cannot be entertained. In support of the contention, learned senior counsel relied upon the decisions of the Supreme Court in Union of India and others versus Jai Prakash Singh and another 2007 10 SCC 712 and Union of India versus Ibrahim Uddin and another 2012 8 SCC 148. Lastly, learned senior counsel submitted that pursuant to the directions issued void judgment under review, the employees have already deposited the amount of contributory provident fund, and the amount deposited by some of the employees have been accepted by the state government, and thus at this stage the order cannot be reviewed. Learned senior counsel submitted that non-implementation of the decision of this court by the respondents have put the employees in precarious condition in as much as they are neither able to utilize the amount of contributory provident fund nor the benefit of pension is extended to them. Mr. Vivek Shri Malli, learned counsel, while adopting the arguments advanced by Mr. N. M. Lodha, learned senior counsel, submitted that both the judgments, that is, the judgment in prem. Stop.